of trust that would say that, yes, sir.
I was just telling sorry you lost.
Very compassionate for a bucket of bolts. I appreciate that, Robbie. And I have to get a job.
Well, the deed of trust said it secured a note signed by husband and wife, but the note
Right.
was just signed by one of them.
Right.
It was wrong, or it was incorrect.
Well, it was, yes, except the court found a paragraph in the standard Fannie Freddie document that it said gave additional information about that. It was a paragraph 13 or something in the deed of trust. So, yeah, I guess that's right. I guess the answer, the right line is the difference between incorrect and missing, unless it's the borrower damage. That would be your corollary.
Are you aware of any other qualifications to the cases we've discussed so far?
Yes. I think there's a qualification if you're dealing with the legal description, which might lead us to
That leads us
the Rose case.
to In re Rose, and we're probably going to have some clarification of this issue from the Fourth Circuit in the next few months. That's a case in which I'm involved as a Chapter 7 trustee, and the deed of trust referred to the legal description, identified the property as being in lot so-and-so, block so-and-so, per the plat recorded with the New Hanover County Register of Deeds. And that was wrong. The plat referenced a property that the debtor did not own. But right after that, and you've seen the standard language boilerplate, right after that it just says street address, and it listed the correct street address, taxpayer identification number, and it listed the correct parcel identification number.
So it had correct information for part of it. It had the right address.
The street address and the tax parcel identification number were correct, but the legal description referencing the property by a recorded plat was incorrect.
So that sounds like law developers. Remember, law developers is they got 4 lots and they put 2 deeds of trust essentially on one, and the other one had inconsistent. It had an address and then it had legal description. Legal description was wrong. So why isn't that the same result?
Well, I argued law developers, but Judge Leonard disagreed, and the distinguishing factor was that Judge Leonard resorted to the chain of title to the property and recognized that the debtor owned the property. The property the debtor owned was the property that corresponded to the street address. The debtor didn't own the property that was described by the plat. Therefore, the debtor must have meant, the debtor must have meant, the parties must have meant to encumber the property described by the street address.
So the court resolved
The court resolved the ambiguity and distinguished it from law developers, saying that the debtor and law developers owned both the lots that were identified, and therefore, if you looked at the chain of title, you would not have been able to resolve the ambiguity. You would still said, well, it could refer to either. The court in Rose used an affidavit that the defendant had submitted, in which a real estate attorney opined that any reasonable person doing a title search would have come to the conclusion that there was a mistake and that the property intended to be encumbered was the parcel identified by the street address.
Was there evidence in the record to come to that conclusion?
There was an affidavit in the record by this title attorney. Now, I will show.
Did the plaintiff object to that affidavit?
There was no objection to the affidavit.
Who's the
So
plaintiff?
was it an affidavit giving an opinion on a legal conclusion?
The question is, was it an affidavit giving an opinion on a legal conclusion?
Well, it necessarily was. Under North Carolina law, the construction of a deed and the identification of the property which is covered by a deed is a matter of law for the court to decide. It's a matter of law, and so the argument before the Fourth Circuit, one of the arguments before the Fourth Circuit is it doesn't matter. It doesn't matter what I say or any witness says. It's not a matter of fact. It's a matter of law.
So you're not supposed to be able to get an affidavit from anyone that just contains an opinion on the ultimate issue of fact or law that the judge is supposed to decide, right?
Right, and getting back to the case, another argument before the Fourth Circuit is that under North Carolina law and the statute of frauds, you're supposed to be able to either or not ascertain the property described within the four corners of the deed, or by reference to any other instrument that's referred to in the deed. Okay? That apparently the extrinsic evidence that Claire helped the court clarify the description in Rose was without the four corners of the deed, was the chain of title, was the affidavit. And so my argument is that's was not appropriate under North Carolina law.
I don't want to pat Alan back too much, but you should read his brief to the Fourth Circuit. It's very good. It sets out these legal issues with North Carolina. It's not in the materials, but it's here, and we have one copy for it's giving away as a door prize. So
My uncle helped copy that brief.
it did, and we appreciate your service, Mr. Angel.
So did Judge Leonard find that deed of trust actually attached to that property, or that there was a mistake sufficient enough to allow him to perform the deed of trust?
The question is, did Judge Leonard find that the deed of trust was valid, or that there was simply enough information that the defendant was able to perform? My interpretation of that opinion, and I invite you to read it. It's in the materials, and you'll find it on the last page. But my interpretation of the opinion is he simply said, since the title included enough information to put the trustee on notice that there was a mistake, that something was not right, okay, the trustee had notice of a mistake and could not avoid the deed of trust. So, in essence, he held that the trustee's 544A1 and A3 rights as a bona fide purchaser were destroyed. Without those powers, I can't do anything. I can't avoid the deed of trust.
Well, this was, Judge Leonard ruled against you. Judge Flanagan ruled against you. But you have soldiered on, and you're in the Fourth Circuit. Now, let's talk about what happened after you lost in the bankruptcy court and the district court. Is there anything out there, perhaps a statement of the law by one of our North Carolina appellate courts, which gives you hope in the Fourth Circuit?
Well, after the district court's opinion, the North Carolina Court of Appeals decided a couple of cases that I believe help my case and are a correct statement of North Carolina law. The first of which is in your materials. It's case number 9 on page 4, the Fifth Third Mortgage Company case. And in that case, Fifth Third Mortgage took a deed of trust securing about $1 million on some property located at 9911 Strike the Gold Lane in Waxhaw, Union County. Okay, but the street address and the taxpayer and the parcel identification number were correct in the deed of trust, but